This is Bloomberg Law with June Grasso from Bloomberg Radio.
These defendants took advantage of Mr. Perry's addiction issues to enrich themselves. They knew what they were doing was wrong. They knew what they were doing was risking great danger to Mr. Perry, but they did it anyways.
Federal prosecutors have charged 5 people, including 2 doctors, in the ketamine drug overdose death of Friends star Matthew Perry last October. U.S. Attorney Martin Estrada said their 7-month investigation revealed a vast criminal network.
That investigation has revealed a broad, underground criminal network responsible for distributing large quantities of ketamine to Mr. Perry and others.
3 defendants have already pled guilty: Perry's live-in assistant, one of the doctors, and a middleman. The case will now focus on the 2 who have pleaded not guilty. Jasveen Sangha, an alleged drug trafficker known as the Ketamine Queen, and Dr. Salvador Placencia. His attorney says the doctor sold ketamine to Perry, but insists he did not break the law.
He was a patient. He did receive ketamine treatment therapy.
Joining me is healthcare attorney Harry Nelson of Nelson Hardiman. Harry, tell us about ketamine and what it's used for.
It was originally developed as a tranquilizer for veterinarians, for large animals like horses. But it's been used increasingly, for human beings as a sedative. And in the last 25 years or so, there's been a growing body of research that it can be an effective alternative for treatment-resistant depression, meaning when people are not successful in managing clinical depression with the sort of standard, more conventional treatments like SSRIs, serotonin reuptake inhibitors like Prozac, most famously, and also for post-traumatic stress disorders. Those are off-label uses, but those are the widespread uses that have really led to this massive growth in ketamine the last couple of years. So we've been seeing some ketamine used in some detox situations, but primarily depression and PTSD are the primary uses that we're seeing for it in the United States today.
Matthew Perry was getting ketamine infusion therapy.
Matthew Perry was getting ketamine infusion therapy. And then at some point, one of the doctors who has been arrested here basically started allowing him to self-administer the ketamine. At least that's the allegation. And the self-administration, it appears, may have come in both the form of infusion at home, meaning through putting it in an intravenous line, or more commonly what we've seen and what's grown in popularity the last few years has been ketamine taken by a troche, which is essentially like a lozenge. And so people basically just suck on a ketamine lozenge and get the same effect metabolized by doing so.
The defendants here range from his live-in assistant, 2 doctors, an acquaintance who acted as a middleman, and a drug dealer known as the Ketamine Queen. Is the prosecution out to prove a criminal network here?
It's not clear from what we've seen so far how much this was a coordinated criminal network as opposed to various individuals being prosecuted for their own personal violations of the laws. So you had a lot of different people with different responsibilities. In the case of the doctors, their writing of prescriptions and their instructions and their sort of permissiveness about giving Matthew Perry the drug is leading to one set of charges similar to things we've seen with doctors and other celebrities, where essentially there's like a gross negligence because they owed a duty, as opposed to some of the hangers-on and the entourage who are directly violating drug laws by handling controlled substances, which ketamine is, a Schedule III controlled substance, without any authorization to do so. So they're effectively being charged as drug dealers.
One of the defendants who pleaded guilty was Perry's live-in assistant. And according to the documents, he gave Perry ketamine 3 times on the day he died. And before the 3rd dose, according to the documents, Perry asked his assistant to, quote, shoot me up with a big one. I'm sort of wondering, you have someone who works for you and you're giving them orders. How much is that person responsible and how much are you responsible?
It's a good question. Look, Matthew Perry certainly was being irresponsible and kind of assigning this responsibility and thinking that somehow he could safely allow a person with no training, no license, no authorization legally to do this, to do it, and the person himself. In the eyes of the law, we only have one person who's alive and hear to point a finger at and to hold accountable. But there's certainly no question that Matthew Perry was complicit in these completely, outside the bounds therapeutic relationships, as is always the case when you have situations like this where you have, famous, powerful people who are managing to hold sway enough over people around them that judgment that most people wouldn't make around their peers, all of a sudden goes out the window. So people do things for celebrities and agree to do things, as this assistant did in administering the ketamine this way, that he probably wouldn't have done, had a friend asked him, simply based on his relationship and, his willingness to go so far beyond ordinary boundaries with Matthew Perry. Yeah, it's an interesting question, but we only, as a practical matter, we have the people who are left to hold accountable and hopefully to send a message that makes other people think twice about playing similar roles.
So the two who have pleaded not guilty are the alleged drug trafficker, known as the ketamine queen, and one of the doctors who allegedly taught Perry's live-in assistant how to inject the drug and injected it himself as well. Does it seem like prosecutors gave the deals to those who appeared less culpable?
So it's clear that the government was looking for cooperation from some of the people who were considered lower-level participants. It's always the case that the doctors are viewed as the most serious targets, I think in part to send a message to other doctors, because doctors have a unique privilege in terms of their proximity and access and ability to put the drugs in the place where they cause harm and where this tragedy happens. So I think the focus in these cases is consistently to make an example of the doctors, because as we see here, we have these doctors who just completely go outside the requirements of the law, outside the bounds of safe practice, and essentially set up the circumstances in which this death occurred. So that's always going to be the top level goal of prosecutors.
And they have text messages, and I think this helps also to paint the doctors in a bad light, because the doctor who's pleaded not guilty texted the other doctor about how much to charge, and he wrote, "I wonder how much this moron will pay. Let's find out." So they charged him exorbitant amounts, like $12 worth of ketamine. They charged him $2,000.
Look, it doesn't get any worse than that. We hold doctors responsible for following the Hippocratic Oath, right? To take care of patients, to do no harm. And it's a tricky subject. Money and healthcare is inherently a fraught topic because doctors are entitled to make a living. But when you see the kind of naked greed here and the dehumanizing language, how much, will this moron pay, where a doctor was so contemptuous of the patient he was responsible for, that he had a duty to, it's really heartbreaking. And I think it shows a level of dehumanization and disregard for responsibility that is not likely to sit well with a jury or a judge, and probably spells not just losing a license, but spending some significant time in custody for this doctor.
Is the cause of death a possible defense? Because the LA County Medical Examiner's Office said that he died of the acute effects of ketamine, but that contributing factors included drowning, coronary artery disease, and the effects of buprenorphine.
Yeah, buprenorphine is a drug that's become the most popular and widespread sort of drug to keep people from craving opioids. So it's been used widely after prescription opioids and other kind of opioid addictions. It's a partial antagonist that basically sort of satisfies that craving without getting people high, and it's safe. People don't die from it. But your question raises a really interesting sort of set of possibilities. Matthew Perry was known, I think, widely, at least from I had heard over the years, to be in really poor health as a result of his drug use, which is often the case. So the question is, was that possibly a factor? Maybe this isn't what actually killed him. And first of all, when we talk about the doctors and the responsibility that they played, they owed separate duties. So their falling below standards of practice so extremely is a problem for them, irrespective of what happened. But for everybody in this case who's charged, there's a fundamental principle that you learn when you start law school and you take first-year tort, which is that you kind of take the person who's harmed as you find them. So, in law school, there's a classic case of the eggshell skull, right, of a person who has a very thin skull and an accident, someone hitting them on the head, a hit which ordinarily would not have harmed a normal person, it's sort of your bad luck that you chose to hit this person, and none of us knows, what are the vulnerabilities of the people around us. So unfortunately, for all of these people who have been charged, the condition that Matthew Perry was in was a risk that they were taking, and they didn't have to know exactly how bad his physical health was. And it doesn't really matter if his death would have been preventable had he been in better health. It sort of goes out the window, and they take him as they found him and are responsible.
So the doctor who pled not guilty to the charges, his attorney says his client sold ketamine to Perry, but he insists he did not break the law. The attorney said he was a patient. He did receive ketamine treatment therapy.
Right. So this is going to be probably the hardest case, the case that does not involve the sort of gross profiteering motive. But this case still involved a doctor who gave the ketamine for self-administration without monitoring. And part of what happened here is something fundamentally unsafe, i.e. a person taking ketamine and getting into a hot tub where they were susceptible of drowning just because ketamine causes disassociation. You're not sharp, right? We have all these settings where you take over-the-counter medications and the warning on the label says, don't operate machinery, don't get behind the wheel of a car. And so too here, you have to wonder what this doctor thought. I can certainly tell you, in advising practices that use ketamine, we consistently advise that people should be monitored to make sure they're not having a negative effect. Ketamine can have dangerous effects, most commonly disassociation and panic attacks. And so we don't know exactly what happened here yet, and I don't know if we ever will, but I think the doctor still bears responsibility for unsafe administration of ketamine and not making sure that it was being used in a setting where there was oversight by a person who was knowledgeable and able to do what needed to be done if something went wrong.
Coming up next, why are federal prosecutors involved in what would normally be a state case? This is Bloomberg.
Radio.
Federal prosecutors have charged 5 people, including 2 doctors, in the ketamine drug overdose of actor Matthew Perry last October. All 5 were charged with conspiracy to distribute the drug and some with other charges as well. 3 defendants have already pleaded guilty: Perry's live-in assistant, one of the doctors, and a middleman. One of the doctors and the alleged drug trafficker have pleaded not guilty. I've been talking to healthcare attorney Harry Nelson of Nelson Hardiman. Harry, I'm not clear on why the doctors didn't just give him the ketamine infusion shots themselves and where the drug dealer came into this.
My sense, just from reading this case and looking at the investigation, is that Matthew Perry had a persistent and significant interest in ketamine that went beyond what most doctors who are responsibly prescribing and administering ketamine will do. And so there was this constant pressure. And there are a lot of questions because ketamine has been a relatively new treatment. We are frequently getting questions from all kinds of practices about how many times ketamine can be administered to the same patient, over what period of time, and so my sense is that there was this constant effort to find the drug that looks more and more like the way that people sort of behave around illegal drugs, where someone who's addicted is constantly looking for a source and a supply and not sort of counting on the fact that routine prescribing through physicians and picking up at pharmacies and so on, or administration in doctors' offices, is going to take care of it. So I just think there was clearly a pressure, in the way that the ketamine was procured that led to all these different sources. This is not what good healthcare looks like. This is what drug dealing and illegal, misuse of drugs looks like. And so I think it's giving us a really troubling picture of how this happened.
And you've represented physicians with celebrity clients dealing with drug addictions.
We've had a lot of cases over the years. Unfortunately, many cases where we didn't get involved until after a physician called us in a death. Inevitably, because celebrity deaths hit the media and make headlines, there's a lot more pressure on both local law enforcement, on the medical board, and in this case on federal authorities, to investigate. So I've been involved in over a dozen cases involving celebrity deaths and plenty of cases where addiction treatment programs and physicians, are managing celebrity patients. And it's challenging because there are some legitimate challenges, right? People's privacy. A celebrity has a much narrower zone of privacy, so inevitably that can be something that creates a little more complication to get effective treatment. But the most common thread for me throughout all these cases is that you had someone whose celebrity led them to feel somewhat entitled to easier access to drugs and medications that we normally make very challenging. We put some hurdles to people getting them, and those go out the window, and we just constantly see physicians and other health professionals making compromises in standards to make things easier. And whether it's out of greed, whether it's out of some kind of romantic idea of your own power being close to these people, whether it's out of respect for their privacy, it's definitely a different world of medicine, and it's certainly a part of practicing in Southern California, where this is such an epicenter of this. But unfortunately, this case feels too much to me like so many of the ones that have come before it, and that I'm sure we're going to be seeing after.
Do most of these cases settle before trial, or have some gone to trial?
It's very unusual that physicians get charged criminally. One of the most famous cases back a few years ago was the Michael Jackson case, where Dr. Conrad Murray was criminally tried. Most doctors who are facing a risk of jail time, along with, of course, their loss of licensure, fight these cases much more aggressively than non-physicians. So I would say that when criminal charges are at stake, these cases have a very high tendency to go to trial. When it's just a licensing issue, sometimes doctors being put on probation or having a suspension on their license, or even in some cases just giving up their license temporarily with an intention to reapply in a few years, it's more likely that extreme cases will settle. But I think it becomes a life and death thing for doctors when they're threatened with jail time and the possibility of never practicing again.
Did you actually talk to investigators about this case?
We did. We had contact with investigators in this case, not for anybody who was ultimately charged, but anytime these investigations are going on, there are plenty of people, who are in the background. And so we did have contact and knew that this investigation was going on for quite a while. It was an unusual investigation because we don't often see federal investigations in celebrity deaths, right? So most of the federal investigations involve sort of broader problems of controlled substance distribution on a wider scale. So that this case was unusual in that respect.
Why were federal charges brought here?
I think what was happening here is that the media attention led to enormous pressure on the DEA as the agency responsible for controlled substances. And we have not seen a significant number of DEA cases involving ketamine. And I think there was a conscious decision to make an example of the loose practices around ketamine in this case that led to this unusual decision to go so deep on this investigation. It's interesting because one of the other big cases that we've been involved in recently, also involving a federal Department of Justice investigation driven by DEA concerns, was related to websites during the pandemic loosening standards for ADHD meds like Adderall. We were kind of wondering, there had been a number of ketamine telemedicine sites that took off during the pandemic, and a lot of wonder whether the Department of Justice was also going to turn its attention to ketamine, and we did not see that same kind of response. And I almost read this case and the federal resources here as sort of a makeup, in a way, of trying to devote attention to ketamine out of concern that it's being misused and being given out too loosely. So I'm not sure. That's just my personal theory, but I'm sure we'll learn more ahead.
What strikes me is that it takes a celebrity for them to spend so much time on an investigation and actually come up with charges when, how many cases are there out there not involving a celebrity?
Yeah, it certainly makes you wonder. Look, the reality is that our media becomes an enormous source of pressure and accountability on our government. And so the irony is that there are undoubtedly many sort of anonymous people out there who also, died unnecessarily or were harmed by unsafe practices around ketamine. And it takes a case like this to get attention. And it's a strange aspect of our celebrity culture that drives so much media attention. In this case, I just hope it ends up being for good in calling more attention to a serious problem.
In light of that, do you think that the prosecution is not going to want to make a deal with the remaining two and want to bring this to trial?
Prosecutors will always make a deal. Prosecutors will never insist on going to trial if the defense and the defendant capitulate and acknowledge wrongdoing. The problem here is that I think the consequences are so extreme for the remaining defendants that there's a pretty good chance these cases will go to trial, and there will be an attempt to make it look like there might have been something less than, kind of a wanton sort of disregard for human life and to make their conduct look better. So I'm not ruling out the possibility that there'll be a guilty plea here. I think, there's always the advantage of negotiating shorter sentencing, but it's very serious. This is a career ending for these doctors, and so there's a pretty good chance they'll go to trial.
Not only that, but if convicted, if you add up everything, not that a judge would do that, but if you add everything up, they could spend their life in prison, both of them.
Yeah, that's constantly the calculus for people facing charges from federal authorities in particular, because when you're facing federal charges, the standards for time off, for good behavior, and reduction of sentences are much narrower. So the big advantage here of some degree of cooperation and a plea would be what kind of sentencing recommendations prosecutors will make. So I do think that would not be a surprising way for this to go.
Are we assuming that the people who pled have some kind of a deal in place about prison terms?
It's a pretty safe assumption that anybody who is cooperating and entered into a plea has had conversations and reached some kind of agreement on sentencing. Typically, the prosecutors don't decide sentencing. They just make recommendations to judges, but there's a fairly high degree of confidence that judges are going to be responsive and acknowledge the cooperation. This is not like a open and shut sort of topic where someone gets a written guarantee that, of what their sentence is going to be for cooperation, but there's enough confidence in the way that our system operates to continue to motivate people to enter into these kind of pleas. It's a safe bet that happened here.
Is a doctor ever allowed to prescribe ketamine to be taken at home? In other words, not in the office under supervision?
Troches, these lozenges, have become popular with ketamine, and they're perfectly legal, and doctors can prescribe them. The question of what's appropriate supervision is a really important one. I will tell you, personally, we have recommended that even if it's happening, by video, essentially by like a telehealth means, that there be a requirement of observation, that somebody, a nurse, for example, be watching the person and they be visible on a camera so that we can make sure that they're safe and that there be immediate people who can step in immediately if something goes wrong. So the law is slightly different from state to state about what the degree of supervision necessary is for safe administration of ketamine lozenges. But it's definitely my belief and recommendation as just a matter of good safety practices that somebody be observed and that there be someone who can step in and a doctor or physician assistant or nurse practitioner immediately available to give instructions about how to handle whatever is happening, whether it's dissociation, which is the most common thing, or some kind of panic attack. And ketamine infusion should not be happening outside of medical facilities. That seems pretty black and white to me.
Well, we'll see if the two remaining defendants strike a deal with prosecutors before the trial. Thanks so much, Harry. That's Harry Nelson of Nelson Hardiman. Coming up, the Delaware Supreme Court approves a nearly $300 million lawyer's fee. I'm June Grasso, and you're listening to Bloomberg. In Delaware, we're used to big numbers. That's what Chief Justice Colin Seitz wrote in an opinion affirming certainly a very big number for attorneys' fees. A $267 million fee award for the attorneys who negotiated a $1 billion settlement in a lawsuit over an acquisition involving Dell Technologies. It's the second highest fee award in the court's history. The ruling may be a concern for Tesla, which faces unusually large fee applications in two separate lawsuits involving CEO Elon Musk's pay package and compensation for the electric vehicle maker's board. Joining me is business law professor Eric Talley of Columbia Law School. So the Delaware Supreme Court ruled that 5 firms should receive $267 million in legal fees for securing this billion-dollar settlement. That's 27%. Would you consider that normal for a settlement like this, or is that above?
Well, I guess it suggests once again, June, that you and I are both in the wrong business.
Yes.
But this is an interesting area of law involving situations where a law firm, without any promise of compensation if they lose outright, brings a case forward and then petitions the court for some fraction of the award. In this case, it was a mediated settlement. And so the idea behind how to come up with that amount has always been somewhat controversial, but the way that Delaware has generally done this is to partially recognize the idea that, these cases can sometimes be risky to bring forward. And as a result, a lot of them are going to end up being losers. The situations where you win are the ones where you actually make any money at all, end up sort of having to sort of compensate for that overall chanciness or riskiness of a set of cases you bring forward. So the idea behind allowing something in the 15 to 30% rate is just not that unconventional. What makes this case an interesting one is that the settlement amount was so large. There really aren't that many cases that are either adjudicated or settle at numbers beginning with a B. In this case, it was a $1 billion settlement. So once you apply that conventional formula to the percentage, you end up with a number that looks like it's about $270 million. And that, just as an absolute matter, can be jaw-dropping to people unless you put it against the context in which these cases generally are decided.
So the investors, led by Pentwater Capital Management, asked Delaware's Supreme Court to reduce the fee, and they proposed a federal court model where attorneys' fees generally decrease as settlement sizes increase. So they said that under that model, it would justify around a 15% ratio.
Yeah, the federal approach to this has been a little bit more along the lines of just trying to come up with an hourly amount, maybe scale that a little bit by risk, and then apply it to the case. The Delaware approach has rejected that. Years ago, in a pretty well-known case, the Delaware courts, decided, no, we're actually going to use what's known as a percentage of the fund approach, in which, depending on how deeply into the case you get, how far towards the finish line of actually litigating the case in court you get, you're going to get an increasing amount of the settlement in a percentage term, and that percentage is not going to start declining as a general matter if it's a large sort of mega settlement, as this one was. Now, the defendants in this case, it wasn't the defendants, it was actually some of the shareholders who had won in this case were petitioning the court to reduce that amount so that they could end up getting more. And this is always kind of an interesting issue, because until you have a prevailing plaintiff, the parties that are all part of the shareholder group and the attorneys are all on the same side. But then once it comes to the question of how much of the attorney's going to get versus how much of the shareholder's going to get, that's when you can start to have these disputes. And the parties, the petitioners in this case, were saying, look, this was such a large settlement. The law firms really didn't need that big of an inducement to bring this case. They don't need that big of an award. Vice Chancellor Laster was the judge that was hearing the case at the trial court level. You should just reduce this to reflect the fact that this was such a windfall that it would just be unseemly to award something north of 25%. He didn't end up buying that, in large part because he was essentially applying the precedent and the rules that the Delaware courts themselves have set down years ago. And while there were a couple of cases where Delaware courts awarded something less than the sort of standard amount that would be appropriate here, which is in that 25% grounds, Vice Chancellor Laster basically said, look, enough of these factors go in the direction of the plaintiff's attorneys actually getting the more conventional amount, and I'm not going to effectively impose a larger tax on the attorney's fees the larger the settlement gets.
I mean, are these sort of slam dunk cases that any lawyers can handle, or are they specialized?
This is actually kind of an interesting area, June, because when it comes right down to it, a lot of these cases, are pretty much going to fall or win on the basis of the effort that the attorneys put forward. The shareholders in these cases play some role, but the attorneys are really, essentially making a bunch of the decisions about, whether to go forward, whether not to go forward, and so forth. And so a lot of their efforts end up basically being critical in determining whether you win and whether you get a big settlement. The economics of this sort of situation actually kind of point in the opposite direction, that the larger the amount of the outcome that's created for the stockholders, if you create enough of an incentive to go for those larger outcomes, the general economics of the situation actually suggests that percentage should be increasing in the award. Judges generally shy away from that because we get into these really, really large numbers. But in this case, Vice Chancellor Laster said, look, I'm not going to abandon the traditional way that we have done this. And in this case, this was a risky case. It wasn't clear they were going to win. Plaintiff attorneys put in a lot of effort. There was a lot of contingencies about this that could have caused this case to go away with nothing. These were reputable attorneys. They weren't sort of bringing this case in order to basically get a quick settlement. They were in it for the long haul, and they pursued this case for several years. And all those are factors that go into a court basically deciding, when combined with the fact that, they were essentially on the courthouse steps when they settled this case, to sort of lean towards a percentage that is more consistent with, plaintiff attorneys that take these cases into the final stages, which is what happened here. It's still, however, a very, very large number. That's something that the petitioning parties in this case basically insisted on making sure that they called the court's attention to it. Ultimately, the Supreme Court said, look, in some cases it might be appropriate to reduce that percentage for one of these mega settlements. However, that's really in the discretion of the trial court. In this case, Vice Chancellor Laster wrote a pretty well-reasoned opinion about why he was willing to go to the percentage that he ended up landing on, and we just don't see enough in the record to suggest that he abused his discretion that is generally given him, so we're going to affirm it.
So the Chief Justice, Colin Seitz, noted that it amounted to an hourly rate of $5,000, which he said was at the high end. I would say it's at the high end. And then he wrote, but it is also legitimate to ask, outside our somewhat insular legal universe, whether the public would ever believe that lawyers must be awarded many hundreds of millions of dollars in any given case to motivate them to pursue representative litigation or to discourage counsel from settling cases for less than they are worth. I mean, I think that most people would consider these fees to be way out of bounds. And isn't there then an appearance problem?
Yeah, I think the optics of large settlements that then end up getting converted into large attorneys' fees, that clearly plays a role in terms of public perceptions. And I think that's what the petitioning parties are really hoping to take advantage of here, to sort of say, hey, listen, this is so large that the average Joe out there is really not going to be able to understand why the fees got this large. One way to think about this, however, is, this is not Silicon Valley venture capital investing, but it's got some of the same features associated with it, right? When you look at a company that says, okay, I'm going to invest a couple $1 million in a startup, 9 out of 10 times, you're just not going to see that money come back because most startups basically fail, or if they don't fail, they disappoint supremely. Only about 1 in 10 really, pays off. And those are the only cases where a venture capital investor actually is going to make their money. The rest of the bets that they make are going to be losing bets. And so the way that you sort of keep people engaged in this business is, assuming it's a valuable business to be engaged in, is to, make sure that for all of the 9 out of 10 cases they lose, they're able to recoup a reasonable return on the cases they do well on. And it's not a perfect analogy by any means, but it's not a bad analogy to describe how attorneys who are bringing cases that are effectively contingency cases think about these cases, right? Most of these lottery tickets are going to be losing lottery tickets, and they hope the ones that are the winners are going to make up for the ones that are losers. Now, when you look back at only the one that won and you disregard all the other cases that lost, it looks like that one winning lottery ticket is paying an unruly amount of capital back to the attorneys. But, in some ways, that is the compensation for all of the cases that the attorneys bring that just don't make it that far to the finish line or don't end up generating a settlement or get dismissed outright. And so it's a very kind of similar analogy, because when you look at, situations where a venture capital fund has put in money into a startup that's done really, really well, it's like, oh man, they made all kinds of money. Was it really that necessary for them to make all that money? And maybe the answer is no, but the analysis also has to take into account the fact that there were a lot of losing bets that were placed alongside the winning one.
Seitz said that at some point, the percentage of fees awarded in a mega fund case exceeds their value as an incentive to take representative cases and turn into a windfall. I mean, does he explain when it's a windfall and when it's not? This seems like a windfall to me.
Yeah, from the opinion, it's a little bit hard to know going in what represents a windfall case. But you could imagine that there might be some cases that are just so good that the worst case scenario for them is that, you're going to be able to recover $500 million for the stockholders. In other words, that first $500 million is almost a freebie. So it doesn't really, require much effort to get the lower end of that spectrum, but then it may require a little bit more to pull in, something on the 600, 700 up to $1 billion in terms of a settlement. I think that's probably the paradigmatic mega settlement type case that Chief Justice Seitz has in mind there. The question and the challenge really is identifying which cases are those where it's really clear that you get, $500 million without barely lifting a finger versus the ones where you got to kind of scrap for every dollar that you get. Now, the case that was at issue here involved the Dell Corporation and some kind of interesting shenanigans that went on in its attempt to try to buy out a class of its own stockholders. They, effectively had, tried to set up this committee to negotiate the price, but the committee was never really empowered to do very much. And Dell sort of had this, almost like a sword of Damocles hanging over the whole negotiation, that they had some rights to almost force these stockholders to pay, but on terms that were really, really hard to figure out. So they ended up successfully buying out the stockholders and negotiating a deal, but there was always a little bit of a tint of, was this negotiated in a kind of a shadow of unfairness? And so it was not a case that was free from complication. It was a really interesting one. In fact, I was commenting on the case when the first facts came out, sort of, thinking this is really kind of one of these edge cases. It's not really clear whether this is going to trigger liability or not, but it was an intriguing case to bring forward. And so, I don't know that back in 2018, when the original facts started to unfold, this was obviously a case of being a mega settlement. But on the other hand, there was a pretty heated contest amongst plaintiff attorneys to try to get representation for this case. So I think that there were several plaintiff attorneys who thought, this looks like it's a fairly winnable case. Ultimately deciding whether this was the type of mega settlement that you really didn't need that full amount of incentive versus one that, really, the lawyers had to kind of scrap for every bit of food coming off the table. Ultimately, the discretion to decide that is probably going to have to fall to the judge that's the closest to those facts, and that's the trial court judge. And that's basically where the Supreme Court went. I think that Chief Justice Seitz correctly probably wanted to say, hey, listen, just because we are affirming here, it doesn't mean that every case that involves a mega settlement is one in which the plaintiff attorneys should automatically expect to get 27% of the settlement. Some of those cases that were kind of like, you could hardly imagine not recovering a large amount, and therefore, there was kind of an automatic amount that was almost going to come forward. Those cases, maybe that would give rise to a reason to shave the percentage a little bit more, simply because the attorneys don't need as much of an incentive to bring it forward.
Speaking of incentives, speaking of billions, let's turn to Tesla, and there are two other legal fee cases involving Tesla. First of all, do you think that this particular opinion, the way the court's upholding the attorney's fees, do you think that will affect the Tesla cases?
Well, I think there's a distinct chance that it will. Look, the fact of the matter is this is a very, very recent case in which the Supreme Court itself has decided to analyze the decisions of a trial court judge in awarding a fee compensation to plaintiffs' attorneys, and basically said, look, if it's a well-reasoned decision, we're going to allow that fee award to go forward. So I think on some level, this decision suggests that the Supreme Court stands ready to defer to a trial court's decision, so long as that trial court's decision is, well-reasoned and well-founded. And so it's hard to read this case without sort of thinking about the potential implications for the ongoing Tesla fee award. Certainly the most significant one is the fee request in the case involving Elon Musk's own compensation, which Chancellor McCormick basically nullified earlier this year. And so that particular case, at the time that the judgment came down, Chancellor McCormick basically nullified stock awards that were a little over $50 billion, actually. And so the plaintiff's attorneys in that case, this was a case that it actually even made it further than the Dell case. It went all the way into litigation. They basically put pretty much from the beginning in 2018 all the way through the end in 2023, all that effort into it. And so when they came forward with their fee request, I think they sort of anticipated the idea that asking for 27% of $56 billion was just not going to be tenable. Where the plaintiffs ended up landing is asking for 11% approximately of the value of the nullified compensation and asked for it all in stock rather than in cash. I think part of this was, essentially an anticipation that for a settlement, or in this case, a judgment that had such a large monetary consequence associated with it, it would be hard to come into court to expect, sort of the standard treatment, the usual sort of formula which was applied in this Dell case would be applied in Tesla. Having said all that, however, the Supreme Court has suggested that, whenever Chancellor McCormick comes back with her decision on the fee request, they are going to at least initially read that with the type of deference that they would, have basically said we're generally going to give to trial court judges who are closer to the facts, closer to the process, and have a sort of a sense of just how risky this case was to bring forward.
Do the trial court judges consider the hourly rate that we just talked about, which was in the Dell case about $5,000, in Elon Musk's pay case, rates of $10,690 and over $280,000 per hour? Is that considered by the court in making the decision?
Oh, it will absolutely be considered because the Musk defendants are going to put it right in front of the judge. And, like I said earlier, I think, the optics of such a large hourly rate are absolutely things that judges almost can't help but consider on some level. Ultimately, my guess is what's going to happen is, Chancellor McCormick's going to have to potentially backtrack back to 2018 and sort of say, look, how likely was it that this case was going to achieve an outcome that was lucrative at all, or alternatively this lucrative to the shareholder plaintiffs in this case? And the riskier the case at the time it was originally brought, and as it's brought through the process, the theory is the more the attorney's efforts are going to matter, and because the attorney's efforts are going to matter more in those truly risky cases, the attorneys are justified in asking for a larger compensation amount. The problem in these Musk cases, particularly the Elon Musk compensation cases, these numbers are just astronomically large compared to other situations that Delaware has had to deal with. Right, the Dell case was notable because there really haven't been that many cases that topped $1 billion. Well, here we're in the Musk case, in the compensation case, we're dealing with an award that tops $50 billion, at least if you view the value of the canceled options. And so this is, orders of magnitude larger than the Dell case or other cases that are in that same league. And so we really are, in some ways, untread waters or unswum waters, I guess I should say, for this type of magnitude of a decision. And so that, in some ways, puts us once again in a zone in which Chancellor McCormick's going to have to figure out, well, how much of this case was kind of like shooting fish in a barrel versus how much really turned on the efforts of the attorney.
It's always a pleasure to have you on the show, Eric. Thanks so much. That's Professor Eric Talley of Columbia Law School. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.